So as we're pulling the slides up, Stefan is an extremely active member of our legal committee. He's experienced in both CEQA and NEPA, as well as the Endangered Species Act. He's also been heavily involved in hazardous waste and land use litigation disputes, and he's also served as a panel attorney for Surfrider. So thank you very much, Stefan. Round of applause, please.
Good afternoon, everyone. Can you hear me?
Yes.
Excellent. I will give you a brief outline on the Brown Act. Indeed, I have about 15 minutes for that. Will be a little more? Okay. It will be quite a challenge. The Brown Act. The Brown Act guarantees the public's right to participate and attend meetings of local legislative bodies. Why do we need that? Why do we need a law for it? Isn't that self-explanatory? In response, the Sacramento Bee came up with a statement as early as in 1952. And they said, public officers, above all other persons, should be imbued with the truth that their business is the public's business, and they should be the last to tolerate any attempt to keep the people from being fully informed as to what is going on in official agencies. Unfortunately, however, that is not always the case. Instances are many in which officials have contrived, deliberately and shamefully, to operate in a vacuum of secrecy. End of quote. The Brown Act was designed to prevent those instances. What is the Brown Act? California state law. Now I'll give you two disclosures. First disclosure. The PowerPoint slide is not a law book. It should be taken with a grain of salt. Second disclosure, I'm not very good with numbers. What do I mean by that? The Brown Act is codified in California Government Code sections 54950 following. And it doesn't end at 54959. If it were, you would have no right to file civil action, and you would have no right to recover attorney's fees and costs. So, take a mental note of that. It ends at 54960.5. And why is it the Brown Act? Not because of Charlie, but because of this man. Authored by Assembly Member Rob Brown, enacted in 1953. The initial version, incredibly, contained only 686 words. When I looked at it yesterday, it was 30 pages. It was enacted in response to local government abuse. And in those days, apparently, public officials went to workshops and study sessions were unencumbered by any public interference. They went about their merry ways. What are local legislative bodies subject to the Brown Act? Well, first and foremost, governing bodies of local agencies. Typical example, City Council, County Board of Supervisors. But it doesn't end there. Governing bodies of other local bodies created by state or federal statute. For instance, housing authorities, air pollution control districts, regional open space districts, the latter two as per an opinion by the California Attorney General. Third, appointed bodies like planning commissions, civil service commissions. Then fourth, standing committees of legislative bodies. That could be a finance committee, budget committee. And governing bodies of private organizations. Now that's a tricky one, because that only applies to them if they are either created by the legislative body or funded by same and at least one member. of the body sits on the board of the private organization. What are not legislative bodies for purposes of the Brown Act? Temporary advisory committees that have been established for a limited purpose and are composed of less than a quorum of the legislative body. Groups advisory to single decision makers or appointed by staff. Individual decision makers, not elected or appointed members of the legislative body. And finally, county central committees of political parties. Now, what you will not see on this slide is state agencies. State agencies are not covered by the Brown Act because they're not local, but they're covered by the similar Badly Keene Act. Central to the Brown Act is the definition of a meeting. What is a meeting? A congregation of the majority of the members of the local legislative body at the same time and place to hear, discuss, or deliberate upon any item within subject matter jurisdiction of the legislative body or local agency. What is not required is that actually an action is taken. It's completely sufficient for a meeting to fall under the Brown Act that they just discussed things without any action. Exempt under the Brown Act are individual contacts between a member and a non-member. Well, why is that? Obviously not the majority of members is involved there. Conferences addressing issues of general public interest. Now, underline general public interest. If they go there and discuss business issues, it will fall under the Brown Act. Community meetings held by another organization. Attendance of other legislative bodies like County Board of Supervisors member goes to the City Council. And attendance of standing committees as observers, again, as observers, not as participants, for social or ceremonial events. What they all have in common is that these are events where normally no action is taken, no deliberation is done, so the Brown Act would not apply. Now, there have been a number of attempts by creative public officials to get around the Brown Act. And they are listed here. For instance, you have a meeting coming up, and you think, well, I should better be prepared for that. So, I will have a briefing of a majority of the members with staff members to prepare for the meeting. This collective briefing falls under the Brown Act requirements. If they do that without posting an agenda, for instance, they would violate the Brown Act. Retreats or workshops, we already covered those. They're apparently still around. Serial meetings. That's a tricky one. There are several kinds. There's a daisy chain. What's a daisy chain? Member A contacts member B, discusses things, member B contacts member C, C contacts member D, and so on and so forth. Each of these meetings is not between a majority of members, but cumulatively, the majority will be involved. So it's simply saying, hey, it's just the two of us, that does not fly. The variations are hub and spoke, which basically means member A calls member B or contacts member B, then contacts member C, member D, member E, so the hub will be member A here. It's the same idea. We have only two people meeting, but the whole idea is to circumvent the protection of the Brown Act. Needless to say, there would typically be violations because I don't expect an agenda to be posted yet. Now, I didn't even know that local agencies on their websites had chat rooms. Apparently they do sometimes. And members have used those chat rooms to deliberate. Again, that would fall under the Brown Act. Informal gatherings mixing business with pleasure. What is that? Well, that's grab lunch. And while we're at it, why don't we discuss this interesting issue just informally? No, you can't do it. At least not with the involvement of the public. You fall under the Brown Act if you do so. Teleconferencing by itself is perfectly legitimate. It can even replace personal meetings, but it has to follow specific requirements which are set forth in section 54.953 of the Government Code. There are three types of meetings. Regular meetings, which are the most common ones, basically following a regular schedule, monthly, quarterly, whatever applies. Special meetings that are called by a board majority to discuss a specific issue. And emergency meetings to deal with emergency situation, and what that is also defined in the code. Needless to say, they are rare. Each of these meetings has different notice and agenda requirements. The regular meetings, we will have an agenda posted at least 72 hours before the meeting. It needs to be posted in a publicly accessible place, and every item on the agenda requires a brief general description of the matter to be considered discussed. Brief is about 20 words. For a special meeting, the notice requirement gets shorter, 24 hours. Notice has to be given to members of the legislative body and media outlets. The notice would double as the agenda. Still, we need a brief general description. Emergency meetings are getting wild. Only 1 hour notice. If there's a dire emergency, then no notice whatsoever. No agenda. Again, this will be the rare exception. As a general idea, you need to have an item on the agenda to be discussed or acted upon, but there are exceptions. Already mentioned the emergency situation decided by the majority. Also, there's a possibility that the need for immediate action comes to the attention of the agency after the posting of the agenda. And then if 2/3 of the members present, or all of the members, if less than 2/3 are present, decide so, they can discuss non-agenda items. Then there is the possibility that we have a meeting and the meeting is adjourned. If the next meeting, the adjourned meeting, is held within 5 days after the adjourned meeting, there doesn't have to be a duplicate agenda. Public attendance and participation. The agenda must allow at regular meetings the public to speak on any item of interest. And the agenda must allow comments on specific items of business before or during consideration. You have no right to comment on something that has already been considered before. You can criticize everything the agency or the legislative body did, as long as you don't cross the line to defamation. There are time limits on public comments that are typically 3 minutes, but there's flexibility that can be adjusted. As for special meetings, the specific rule is that you have to limit your comment to the agenda item. Not everything is public. You have closed session meetings under certain circumstances. For instance, decisions regarding hiring, firing, disciplining of employees of a public agency, so-called personal exemption. public security decisions with law enforcement, and most common litigation advice of legal counsel, or either pending or threatening litigation, considerations of labor negotiations, discussions of price and payment terms of real estate transactions. Only that, not any other terms of a real estate transaction. Those closed sessions must be designated in the agenda. So, what can you do if there is a violation? We can file civil action. Anyone who is interested, the district attorney as well. The scope of the civil action would be either injunctive, mandatory, or declaratory relief, or to void action violating the Brown Act. But before you file an action, you would have to submit a written demand to cure and correct to the local legislative body within 90 days of the violation, or within 30 days if the action that you attacked was taken in open session in violation of agenda or notice requirements. Then, which you will not see here, but the legislative body has 30 days to cure and correct. They can do either proof of one or two things. They can do nothing. And if they don't do anything, you wait until the 30 days run, then you have 15 days to file a lawsuit. If they serve a notice to cure and correct, then from the time of receipt of the notice, you have 15 days to file action. If you prevail, you will recover attorney's fees and costs. There's also criminal liability, and that doesn't fly very often. The liable member must attend the meeting. Action must be taken in violation of the Brown Act and must be intended to deprive public of information, and there must be knowledge that the public is entitled to information, all of which has to be proven beyond reasonable doubt. And there will be rarely any convictions based on that statute. If there are, it's a misdemeanor still, not a felony. So some argue that the Brown Act doesn't have teeth, and they're basically, in saying so, they focus on the criminal liability, which does exist on paper, not in practice. But certainly it's a far step from the time we had in 1952. Thank you.